show How to Probate an Estate. Virginia probate is a process to settle the financial affairs of a loved one and then transfer the probate assets that remained to the beneficiaries. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's loved ones. Some probate train rides are short, while other probates seem to never end. But not all probate journeys end happily, because some estates are insolvent because there are more debts than assets. In our show today, we are going to focus on the challenges you face in administering an insolvent estate. Throughout this show, we will urge you to proceed slowly and seek the advice and guidance of an experienced attorney on this especially treacherous journey, because a single misstep can expose you to personal liability. With us today are two prominent Northern Virginia attorneys to share their insights and provide guidance on this challenging topic. Gretchen Gay Minkin is an attorney with the Alexandria law firm of Wade, Grimes, Friedman, Sutter, and Leshner, PLLC. Gretchen focuses her practice on estate administration and estate planning and is licensed in Virginia, Maryland, and the District of Columbia. Joseph Stewart has practiced law in Northern Virginia since 1993. He concentrates his practice on contested or complex estate, trust, and elder law cases, adult guardianships, estate and trust administration, and estate planning. Please welcome attorney Gretchen Minkin and Joseph Stewart. Thank you both for joining us today.
Thank you for having us.
Insolvent estates. Joseph, it's a term that is a challenging term. Tell us a little bit about what that really means.
An insolvent estate is one where after a person dies, their assets are insufficient to pay all their debts. And the assets would be anything that they own solely by themselves, real estate, bank accounts, investment accounts, and the like. It doesn't include the proceeds of life insurance if a beneficiary has been designated, or the assets in a retirement plan if a person's been designated as a beneficiary. And it does exclude most types of jointly held assets, such as real estate that's owned jointly with another person.
Okay. So, a lot of people say that it's really risky to qualify to be the administrator of an insolvent estate. Tell us a little bit about the risks that you tell people about when they first come and talk to you about this.
Well, being an executor or administrator carries a lot of duties with it, and in an insolvent estate, so there's normal duties and risks with any estate, but with an insolvent estate, if you have more debts than assets, then you can only pay the debts according to a certain priority and a number of classes of priorities, and if you pay a debt out of priority, then you will be personally liable for that debt. That is to say, even if you pay it from the estate, if you pay it in the wrong order and the wrong priority, then the local court will force you to repay those funds from your own pocket to the estate in order to get the priority and the orders correct.
Okay. Now, Gretchen, so then one of the big tasks is, of course, to determine just whether or not you have an installment estate. How do you go about doing that?
I generally advise people to go through the mail. So locate the decedent's mail, and if they don't have access to the home, then to have the mail forwarded to their home address. Mm-hmm. Because most people still get bank statements via mail, credit card statements via mail, things of that nature. So basically, sure. It's a journey, and it's a process it's kind of a puzzle. You're trying to figure out what assets people have, and to do that, you need to have access to information. So it's possibly a credit report. If you can locate a credit report, that's helpful. The mail, there are a variety of ways to do it.
Okay. Tax returns
returns are helpful. If you can get a hold of court records, you can look for judgments and liens.
Okay.
It's a wide variety of things that you can do. It's just you're somewhat restrained because you are not appointed as an executor at that point.
Sure.
And so people aren't required to provide you with the information that you would look for.
So they may be a little reluctant to tell you stuff. Right. Joe, if you believe that an estate's insolvent, does that automatically mean that someone should not qualify?
No, you'd have to look at what assets there are there, and what the debts are, and what I would say is whether there's something that needs to be saved.
Mm-hmm.
That is to say, oftentimes a person dies leaving minor children or surviving spouse, and those are protected individuals. They can file claims to assets in the estate and get paid ahead of creditors. Oftentimes, family members pay for funeral expenses, and even in an insolvent estate, those expenses can be partially reimbursed from the estate.
Okay.
So it's looking at whether there's some legitimate persons to be protected or assets to be protected in the estate to determine whether you qualify or not.
So it's not just automatic. We need to have some evaluation about the circumstances because there could be some reason to qualify. Now, Gretchen, often you someone has passed away and people want to start writing checks. Okay, should creditors be paid right away?
Absolutely not. The only debt that you should be paying at that point is the funeral expense, and that's just to get the death certificates. And keeping in mind that the funeral expenses, if it is an insolvent estate, those are capped at $4,000 in the order of priority. So if someone pays that personally, they may not receive full compensation reimbursement should the estate be insolvent. So I generally recommend people do not pay any creditor bills until you have a full grasp of what assets and what debts exist for the estate.
So once again, this is a word of caution to our viewers about don't being in a rush, one, to qualify, and take the time, as some of our other guests have suggested, and figure out just what exactly is the landscape as far as creditors and debtors. What are some of the other considerations that arise at this stage of a potentially insolvent estate, Joe, that you come across? Anything in particular that comes to mind?
Well, if a person dies owning real estate, then you have to carefully consider whether you want to go forward with probate because oftentimes the real estate is heavily mortgaged, and you have to determine whether it's worth attempting to save that property. Mm-hmm. If you do nothing, then the property may go into foreclosure, but that might be the best result overall to let the property go, especially in the last, let's say, 7 years or so. You've had issues with that. That is to say, properties being underwater because of mortgages that were obtained when the market was high. You need to first determine whether there's enough money in the estate to even cover the administrative expenses of opening an estate. And if there's not, then oftentimes you might conclude it's not worth opening the estate at all. And you may have some options that way. Mm-hmm. And then, as I said before, you have surviving spouses and minor children to protect. So those can be adequately protected, even in the case of an insolvent estate, because they're paid early on in the process. They have a higher priority than things like credit card debts or even medical expenses.
Okay. All right, so there's a lot of factors to take into consideration. It's not a yes or no answer. It's definitely not black and white. Well, the things you both have mentioned is that if you have an insolvent estate, that there is in fact a statute that Virginia has laid out that sort of tells you the order in which people get paid. So what I like, there's basically 9 categories. These are not things for the uninformed to just take upon themselves, because these categories can be complicated even for lawyers to figure out. But let's kind of walk through those together. And Gretchen, I'm going to ask you just to begin, because the categories start from category 1 to 9. So the top category, category 1, has got the highest priority. As we work down, we get to the lowest priority, which is category 9. So in category 1, it's cost and expense of administration. What's typically going to be captured there, Gretchen?
The court costs, fees associated with managing and closing out the estate. So that's going to start with, you're going to have court costs, you're going to have attorney's fees, accountant's fees, managing the assets. So your job is to maintain assets. Mm-hmm. So it's things, if there's real estate, it may be a mortgage payment or continual mortgage payments. It may be estate income taxes. There are a variety of things that fall into that category, but they're all encompassed as those costs for keeping the estate up and running.
Okay, so that's category 1. So then the next category is a collection of special statutory allowances, which Joe mentioned as one of those considerations where you might want to qualify anyway, just to protect those. So what's included in those statutory allowances?
So there's the exempt property allowance, which is $20,000 worth of tangible property. And if there's insufficient tangible property to encompass that $20,000, it can be subbed in with cash. So it just depends on what assets they have. There's also the family allowance, which is $24,000 right now, and that can be for the surviving spouse, or if the surviving spouse is not, if there is no surviving spouse, then it'd be for the minor children.
Okay.
And that's cash. There's also the homestead allowance, which is for the surviving spouse, and that's a $20,000 allowance. Now that one there's some drawbacks to that one because there's a give and take. There's some things that you'll have to give up to get that.
Okay.
And there's also the marital share augmented estate election. Has a variety of names, but it's essentially for the surviving spouse if they wish to take 1/3 of the total estate, and that's not just probate estate, that's non-probate estate, and that one's definitely more complex. I wouldn't recommend anyone just jump into that without actually understanding what all the assets are,
Okay.
both non-probate and probate.
Okay. Now, in the case of the exempt property, if someone doesn't want any of the property, they just want cash, they can just take cash.
They can.
So that's one of those things that's available. Definitely the marital, the claim by the surviving spouse for the deciding whether they want to take the homestead exemption or the marital share is a complex calculation.
You absolutely have to look and see what the assets are, what the debts are, whether it's beneficial to make those claims or just to let intestacy or the will take its course.
But you can't sit on your hands. You have to decide.
Correct.
So
You have a time limit.
Clock is ticking on that one. The third category, which was mentioned by both of you, is funeral expenses, and this is the one where people often get tripped up on. So tell us a little bit about that particular one.
So I mean, we all know funeral expenses. They're large. It's a large. $4,000 doesn't cover much of anything, frankly. So you're going to have an excess that's not going to be statutorily in that class of claims. So the funeral costs include things like cremation, casket, burial costs, cemetery plot. It's whatever you would normally deal with a funeral home on. So the reality is it's going to exceed $4,000. I have yet to see it be less than $4,000. So what happens is anything that's over $4,000 falls into the general creditor at the very bottom of the totem pole class.
Okay.
So it's ideal to stay as close as you can to the $4,000, especially if you're paying personally, because you may have no guarantee of reimbursement.
And this can be a source of some conflict within the family because somebody may have to step up to give their credit card in order to pay that bill, and with the expectation they're going to get paid everything back, and then come to find out they can't get it all. So do want to proceed cautiously. Now, Joe, we move into category 4, talks about debts and taxes with the federal law. What would be, I guess that's self-explanatory, or is
Well, tax debts or taxes owed to the IRS by the person who died. So they may owe taxes from prior years. They may owe taxes for the last year of their life. So they have that's a preference under the law. So you have to pay the IRS, unsurprisingly, before you pay a lot of people, and to keep them happy.
Okay. Then the next category is category 5. It has to do with various medical expenses associated with the last illness and so on. Tell us about that category.
Right. The next category is medical expenses or physician expenses, and the statute limits payment of those expenses to $2,150 for expenses at a hospital or a nursing home, and up to $425 for each physician. That is, each hospital can be paid $2,150, each nursing home, and each doctor to whom money is owed, up to $425 per doctor, can be paid in that after you've paid the expenses above it, the taxes and everything else.
Okay. Again, we're working our way down the priority list. So then category 6, I guess, is the counterpart to category 4. These are the debts and taxes that would be due the Commonwealth of Virginia.
Right. And similar to the IRS, any state income taxes or other taxes that are owed the state, Virginia has other taxes other than income taxes, so they could include property taxes or other taxes owed to the Commonwealth in particular. Property taxes would probably come down to local level, but taxes that you would pay to Virginia state.
Okay. So Gretchen, now we're getting into the last third of this, which these are the folks that are they often don't get what what they're owed. These are various debts that are owed because the decedent served as a fiduciary.
Right, it's kind of rather obscure, but it's if the decedent was serving as a guardian or conservator for another party, then they may have things that are due to them or due elsewhere. So that one's not a normal one you've come across.
It's not, but that's number 7. And then number 8, we get down to debts and taxes that are due the localities and municipal corporations. So is that the third category of taxes?
That's your personal property tax, so your vehicle tax, whatever else you have that would qualify under that category. Your real property tax, so your real estate taxes.
Okay.
Things that are due to your county or your city, wherever the proper jurisdiction would be.
Okay, so then the last category is category 9, which is the death section, because those people often don't get their full dollar. Tell us what happens there.
So those are I call them the bottom of the totem pole. They are they are your general creditors. They're credit card companies. They are your leftover funeral expenses, the leftover medical bills, any other unsecured debt that the decedent may have. And generally, if you're dealing with an insolvent estate, it's very unlikely you're going to get full payment at that level. It's done pro rata based on the entirety of the debts area. It's based on pro rata among class.
Okay.
So once you get down to this level, there's not much to go around, and there's generally not going to be full payment. Oftentimes, the creditors will negotiate. They'll agree to accept less, and that's with regard to credit card companies in particular.
Okay. Well, let's talk a little bit about that, because I think as you look at these categories, some of these creditors are not going to get paid full dollar. So, Joe, if you first start in the administration of an insolvent estate, and some credit card company comes over to you and says, "I'm willing to take 25 cents on the dollar to settle my thing up right away," what would you say to them if you think you have an insolvent estate?
Well, I'd say I'll get back to them, because I think you have to first get a very good idea of what you have and what the debts are. And it can be complicated because you have to figure out what's in each category and make sure you have any money to pay the category 9, the all other claims, the bottom of the totem pole. So you'd have to delay on that.
And the risk that you run into there, Gretchen, is you actually make that deal because you're thinking you're making a great deal.
Right. I mean, I get the creditor calls all the time where they offer to give me 75% of what's due. We'll take 75%, and frankly, I don't commit to anything until we are at the point of actual distribution, and at that point, generally, what they're willing to accept has decreased.
Sure.
So they want payment as soon as possible, but you as the executor administrator, you shouldn't be paying any of that if you're dealing with insolvent until the very end.
So 2 things I know you've mentioned. One is we've talked about is that if it is an insolvent estate, then there's no more interest that's accruing on that particular.
If it's an insolvent estate, the law in Virginia is that the interest cannot accrue.
Okay.
So if it's solvent, you are liable, the estate's liable for the interest. But if it's insolvent, the estate is not liable for any interest accrual.
Okay, good. And if it happens, unfortunately, you make that deal too early in the process, and they're actually owed less, then you as the fiduciary could end up owing money back to the estate. Is that right?
That's correct. You're personally liable for debts that are paid improperly.
Okay, so that leads us to our next discussion, which is what's the get out of jail free card that folks really can go to, because they're not lawyers, and they have a whole host of debts that can go in any number of categories. Sometimes they belong in more than one category. What's the role of the Commissioner of Accounts, Joe? How does he figure into this process?
Well, the Commissioner of Accounts is appointed by the court to review accountings that are filed by executors and administrators. And one thing that the commissioners will do is a hearing on what's called debts and demands. So you can, in a case like this, you'd want to request a hearing before the commissioner before you pay any questionable debts or expenses of the estate, in order to get his determination of the priority of the various debts. And if you have to pay in a category pro rata, meaning proportionally in any one category, get his approval of a plan to pay the pro rata portion. So he'll conduct a hearing. Sometimes they're oftentimes very brief hearings, unless there's some dispute about what's owed. And when the commissioner has reviewed all of the facts in the hearing, then will ultimately issue a report, which, if you follow it, if the executor follows it, then he can be protected from any liability.
Now, that's an excellent process to go through. Gretchen, tell us a little bit about how our viewers, if they wanted to initiate that process, how do the commissioners normally have you start that process?
Well, it generally has to occur 6 months after you've been appointed. But generally, I send a written letter to the commissioner and I ask for a debts and demands hearing explaining that I believe we have an insolvent estate. And at that point, they'll put it on the calendar, we'll schedule a time and date, and once that's been set, if there are any creditors that I'm disputing a claim on, we have to give them notice of the hearing because they have a legal right to be present. And then my job at that point is simply to determine what all debts we have and put together a comprehensive list with the documentation supporting it to give to the commissioner to make his life a little easier.
Sure.
He gets a nice packet, and from there he decides, he issues his report based on what we've provided him and what he believes is the appropriate order of priority.
So that is really something that's very, very critical to do if you have an insolvent estate. Do not try to figure that out by yourself.
Right.
You need to have the commissioner rule on that for you. So, we talked about insolvent estates, we talked about risk, we talked about how we can monitor those risks, and maybe, control those risks for ourselves if we unfortunately get ourselves qualified to administer an insolvent estate. You guys are experienced practitioners. How much some final words of wisdom, some guidance that each of you could share with our viewers if they happen to be thinking they have an insolvent estate or find themselves with an insolvent estate? Gretchen?
My recommendation is if you believe that you have an insolvent estate or you may have one, that you seek legal counsel. They're very complex and they're tricky. And frankly, the average person who isn't accustomed to this type of practice area is going to find themselves lost and possibly with some personal liability. So the best course of action is don't do anything in terms of paying debts. Gather the information and come talk to an attorney.
Okay. Well, I think that's good advice. Joseph, how about yourself? What would you add to those thoughts?
Well, I think oftentimes people get tangled up in what assets are in an estate. For example, insurance proceeds, if you're a beneficiary of insurance, you don't have to use those proceeds to pay debts of the decedent. So the debts of the person who died, his estate is liable for those. So you should be careful before you start paying out monies from a source that's not in the estate, retirement funds and the like. And I would echo what Gretchen said, that you'd want to see an attorney because it is very complex. Some estates can be handled by lay people. They're not difficult, but others like insolvent estates are not that way. They're tougher.
Very much so. I want to thank both of you for taking the time to talk today with us about insolvent estates. I mean, while it seems fairly straightforward to those of us who might be in the field, that the reality is, as you said, that it is a real trap for the unwary. And the slightest misstep along the way can definitely expose someone to personal liability. So thank you very much for taking the time to share your thoughts and your expertise.
Well, thank you for having us.
You're very
Thanks,
welcome. The administration of an insolvent estate is something very serious. Gretchen and Joe have done a wonderful job of identifying many traps and pitfalls that arise in such a probate. Their comments echo what we heard in earlier shows from local Commissioner of Accounts, Fairfax Commissioner Jack Russ, and Arlington Commissioner Bill Murray. Each have stressed that if you think the estate is insolvent or may become insolvent, do not pay anyone and contact the Commissioner of Accounts to schedule a hearing where he or she can then determine exactly which creditors get paid and in what amount. The Commissioner's decision will serve to protect you from liability and allow you to proceed in an orderly manner to wrap up the insolvent estate. I hope you found the discussion on the administration of an insolvent estate helpful. But again, this discussion is no substitute for the advice and guidance from a probate attorney who is experienced in dealing with insolvent estates and can provide direction on how to proceed based on the specific facts of your estate. All too often, folks act too quickly to pay creditors and then in the course of administering this insolvent estate, find themselves personally liable for disbursements they should not have made from limited estate assets. Proceed cautiously, and again, seek legal advice early in the probate process so you do not make such a mistake. This brings us to the conclusion of our show today on insolvent estates. Replays of this show, along with other helpful material on the topic of today's show, will be posted on the Probate Nation website. On behalf of myself and the Probate Nation, thank you for visiting with us.